Well, good afternoon, everybody. I'm Steve Felano, founder of 2ANYS, also an active candidate for Erie County Sheriff at the present time. Want to thank everybody for joining us today for a very momentous announcement and a big step forward for Second Amendment civil rights, not only in Erie County, where we're located right now, but all across New York State. We gathered today to announce a writ for certiorari has been put together and sent off to the U.S. Supreme Court for review. And this deals with a 6-year-old case, just about 6 years old, that seeks to reverse on constitutional grounds the entire New York State pistol permit regime. So I'm going to talk about that for a bit here and give some final comments on this legal matter that's very important. For more than a decade, county judges across New York State have ignored the U.S. Supreme Court's historic District of Columbia versus Heller decision. This decision, of course, held that the Second Amendment protects an individual right to keep and bear arms disconnected from service in a militia. It also articulated two restrictions, and two restrictions only, on firearms ownership and carriage. These include felony conviction and/or involuntary civil commitment under mental health law. Through a calculated conspiracy against citizens' Second Amendment civil rights, county judges from one side of the state to the other have forced an imaginary may-issue concealed carry permitting scheme on the residents they're supposed to serve. This scheme mandates that citizens treat their county government like an overbearing parent, writing a Mother May I letter to judges asking for permission to exercise a civil right guaranteed by the U.S. Constitution to all who do not fall into the restricted classes articulated by the D.C. versus Heller decision. In the current era of rising political violence, heightened use of government force to maintain the illusion of democratic legitimacy, and Albany's fumbled bail reform rollout, New York State's pistol permitting scheme places all New Yorkers at risk of severe bodily harm and death. New politically motivated domestic terrorism laws and escalating Army National Guard deployments contrived for media consumption will not keep New York residents safe. The Second Amendment will, and it's time for county and state government agents to accept this obvious fact of life. It's time to consign New York State's unconstitutional, authoritarian, and racist pistol permit regime to the dustbin of history where it belongs. All across New York State, county judges ignore federal law, and they simply hold that all citizens should be denied the right to keep and bear arms outside the home for any reason, or for no reason at all. This permitting scheme, devoid of constitutional justification and completely conjured out of thin air by rogue county judges, is clearly unconstitutional, and it must be reversed. 2ANYS is pleased today to continue its partnership with civil rights attorney James Ostrowski to petition the U.S. Supreme Court to decisively reverse New York State's unlawful pistol permitting scheme and free all New Yorkers' Second Amendment civil rights from an artificial prison built by the authoritarian bureaucrats and the kleptomaniacs that control state government. I want to talk for a moment about why this particular case is different from others that are pending before the Supreme Court right now. There is an active case right now that's pending Supreme Court review regarding the pistol permit regime, but this one is different because the primary argument it focuses on is the fact that the Second Amendment is primarily there to protect you from government tyranny. And the other cases that you generally see come before the court do not make that argument. So very important to focus on that fact, and we want to know what the Supreme Court of the land thinks about that argument because we've not gotten a response from that argument from state courts or federal courts to date. I also want to say that the U.S. Supreme Court is not the last word in this argument, it's the first word. If we are not granted certiorari, if the U.S. Supreme Court declines to hear this case or rules against us if they do plan to hear the case, obviously that doesn't mean that this fundamental right to keep and bear arms outside the home simply vanishes. It's a right that pre-exists government. It was there long before the U.S. Supreme Court was even constituted. It will be here long before the U.S. Supreme Court stops hearing cases. Finally, I want to call on all candidates in the Erie County Sheriff's race to endorse this lawsuit. This campaign for Erie County Sheriff should be squarely focused not on compelling citizens in Erie County to bow to edicts from Albany, but it should be about what the sheriff is going to do to protect the citizens of this county against imperial unconstitutional edicts coming from the governor's mansion. This case obviously does that, and all the candidates in this race should join me in endorsing this particular lawsuit. I would also call on all sheriffs all across New York State to do that as well.